The well-publicized case of King versus Dubery and others has helped clarify the concept of deathbed gifts. In this case, Mr. King resided with and cared for his aunt. When she passed away, he claimed that she had made a deathbed gift to him of the house about 4 to 6 months prior to her death, and had in fact handed over the title deeds. Unfortunately, there was no such provision in her will. Several animal charities who stood to share the residue of the deceased estate challenged this claim, and in July last year the claim was heard before Charles Hollander Q.C. at the High Court. In English law, deathbed gifts require that the giver must be aware that their death is imminent, and the gift can only take effect in the event of their death. In this case, there was no evidence to show that Mr. King's aunt was thought to be seriously ill. She had not indicated that she expected to die shortly, nor had she recently consulted a doctor. Moreover, she was not scheduled to undergo risky surgical procedure, nor undertake a dangerous trip. The court did, however, hear evidence that Mr. King's aunt had made several unsuccessful attempts to alter her will in order to leave the house to her nephew. In the judge's view, these attempts were sufficient to demonstrate that she had become increasingly preoccupied with her impending death. Taking this and the case of Valley versus Birchwood, in which the court found that a period of 5 months between the gift being made and the death of the giver satisfied the test for deathbed gifts into account, the judge ruled that Mr. King's aunt had indeed made a deathbed gift of the house to him. The charities appealed this decision in the Court of Appeal, and in overturning the High Court's decision, the appellate judges held that the giver must believe that death, for some reason or another, is impending. The judges observed that in most of the reported cases of deathbed gifts, the gift had been made when the giver was gravely ill, often only a matter of days prior to their death. Mr. King's aunt, said the judges, had no reason to consider that her death was imminent. They further held that her attempts to change her will were not necessarily made in order to make a deathbed gift of the house. Finally, the judges concluded that the case of Valley versus Blackwood, on which Mr. Hollander had based his decision, had been wrongly decided.